All rise.
Please be seated. Good afternoon, everyone. We're here for oral argument in cause number CV160328, McMullan versus CHW. I will alert the parties that these proceedings are being audio and video recorded. So we ask counsel to please identify yourselves and the party that you represent at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel, you are responsible for watching your time to make sure if you want to reserve any of that time for a rebuttal, you need to do that. We have read the briefs. We've conferenced this case. And counsel, you may proceed.
Thank you. Good afternoon, Your Honors. I'm Jeff Bauman. I represent the plaintiff's appellants, Leah McMullan, her husband, and their daughters. My intent is to reserve 5 minutes of my time for rebuttal. We're here today because of egregious, intentional, ongoing violations of the rules of discovery, rules of disclosure, and of a very specific court order requiring medical records to be produced. And those records were not produced. The obligations and orders which applied to the defendant, Dignity, were ignored. Critical facts were misrepresented in discovery, they were misrepresented in pleadings filed with this court, and they were misrepresented in oral argument before the court. These violations undercut the foundations of the court system in any system, but in a state like Arizona, where we depend so heavily on Rule 26.1 as the primary method of learning about our opponent's case, which imposes mandatory obligations to disclose, not just once but throughout the case, any facts that are relevant, and to preserve and to present any evidence, including electronically stored evidence such as medical records. Those obligations must be met, and when they're not met, then there has to be consequences. The test is not whether or not, as a result of the failure, the outcome would have been different. The test is simply, did the failure to disclose substantially interfere with a party?
Test for what?
Whether or not the disclosure was material, or failure to make the disclosure was material and something that the court should take action upon.
No,
that comes out of the
material. Sounds like the standard is whether it would have affected the outcome.
I'm sorry, I did not hear you.
If the question is whether the failure to disclose was material, then wouldn't outcome effect be critical to that inquiry?
The question is if the information is material. The effect is not that it changed whether or not summary judgment was granted or what the outcome of the trial. The test is what did that substantially...
I'm sorry, are you suggesting that we should reverse even if all of the disclosures you argue should have happened wouldn't have affected summary judgment?
I don't think that you're going to have to go to that, and let me explain why.
Okay.
Because what I'm going to do is I'm going to explain 5 facts that we now know that, had they been presented to Judge Ray, would have prevented any court from granting summary judgment. And the first one of these was Dr. Brown was a credentialed doctor who was on call in both ERs run by Dignity for at least 10 years, and that encompasses the entire period that Dr. McHale was the chairman of the emergency room department. Fact number 2. On April 16th and 17th, Dr. Brown was brought into the emergency room in extraordinary circumstances, handcuffed to a gurney.
Well, let me back up. Would the disclosure of that information that both had been part of the Dignity for 10 years, What would that suggest?
The disclosure that Dr. McHale,
I'm just thinking, what would that suggest?
that Dr. McHale was the chairman of the emergency room department and sat on the credentialing committee, that would not suggest it. It would tell us that the chief administrator for the hospital was in the room with Dr. Brown during this period of time. And a big part of the argument up until the date of May 7th, when we finally got the truth, was that Dr. McHale was not part of the administration. He was merely one of 90 independent contractor doctors who had coverage, and that nobody in the administration had any reason to suspect that Dr. Brown had even been in the hospital. And what that proves is that the chief administrator, the person who had the power and the authority to initiate the investigation into Dr. Brown's conduct, was there, and he knew or should have known that Dr. Brown was one of his doctors, because Dr.
How
Brown...
many doctors are we talking about with Dignity Health?
With Dignity Health,
That have been credentialed at both hospitals?
I do not know the answer on how many of them have been there.
Was Dr. McHale part of the credentialing team for Dr. Brown?
Yes.
For Dr. Brown?
Yes.
When did that take place?
That took place when he was appointed as the chairman of the emergency department, and I believe that was in 2004.
So Dr. Brown was not credentialed prior to 2004?
Dr. Brown was credentialed before 2004, I believe. And I think
My
that...
question was, did Dr. McHale, was he part of the credentialing team, the team that actually credentialed Dr. Brown?
Doctors had to be re-credentialed every 2 years, so yes, he would have been there on the re-credentialing.
Would have been and was are two different things. Do you have any evidence that Dr. McHale had interacted with Dr. Brown?
We have Dr. Brown's statement to Dr. Suture as part of the investigation that he knew Dr. McHale because he had served on call with Dr. McHale in the emergency department. That's one admission, but
The quote, I believe, was a little bit cryptic, the way it was written, but I think what he said is that both of them took calls. I don't know that he said, I served with Dr. McHale on call at the hospital.
I believe what the quote was that I remember being in the emergency department. I remember Dr. McHale. We were on call together. But
Was Dr. McHale deposed as to whether he knew Dr. Brown?
Dr. McHale was not deposed because we were fighting with the parties over the HIPAA claim that Dr. Brown was asserting.
At one point in time, though, however, as I think I understand the record, the court said, if it's just about whether he knows it and separate and apart from HIPAA, you can depose him.
But that issue didn't come up until the May 7th, 2015 argument. Because,
but why wouldn't it? You advanced a negligent credentialing claim. Isn't that exactly the kind of evidence that you try to build immediately?
Well, we didn't know that Dr. McHale was on the credentialing committee. The information was held from us. That's why it's important. Had we known that Dr. McHale was not just one of 90 guys completely unconnected from the administration, then we would have. That's why that's why the active misrepresentation of who he was and the hiding of the contract until the day of the argument.
Well, active misrepresentation as to who he was. Were you ever told by the other side that he wasn't on the credentialing committee?
Yes.
That they said they flatly denied something that later turned out to be
yes,
false.
exactly.
Okay.
They said he was not connected to the administration. He was not an administration official. And even after we found out that he was the chairman of the administration department and pursuant to the bylaws would be on the credentialing committee, they denied that was the case as well. So there's still an open. And by the way, discovery was still ongoing at this point.
May I ask a question? Who was deposed before the motion for summary judgment was heard?
Dr. Peters, Dr. Brown's partner, Dr. Mabin, who is Dr. Brown's partner, Dr. Brown, and...
Anybody associated with the hospital?
Not at this point yet, no.
Okay, and
oh, and the experts, by the way, and the hospital's experts, and the hospital's experts had agreed with many of the positions we had.
And so then when the motion for summary judgment came along, one would think, if you still felt you needed this information, that a Rule 56F, back then it was Rule 56F, request would have been prudent.
Well, what we did was, we got the information. I got this information handed to me 2 minutes before the oral argument started. So at that point, I was actually still under the impression that he was just an emergency room doctor, and so I was reading this while.
But let's say that was true, that he was just an emergency room doctor. Surely, you were going to make an argument in response to the motion for summary judgment that there was some basis for knowledge giving rise to a duty to decredential.
And what we did was our expert agreed that if he was just an emergency room doctor, Dr. McHale had to have specific knowledge. He had to know Dr. Brown was another physician. What his position as the chairman means, especially given the events that happened the following Monday and Tuesday, means that he now has an obligation to make sure that Dr. Brown isn't one of his guys. And what happens Monday is extraordinary, because that's when the podiatry board, Sarah Pennett's chairman, faxes, calls, and comes over with an emergency subpoena and grabs Dr. Brown's records. The very next day, after those records have been subpoenaed, and this is a big deal when this happens in a hospital, our expert says after that is something that would have gone all the way up to legal to make sure the subpoena was being complied with. Well, what happened the next day is Dr. McHale went into the hospital and removed from his records all of the bad things he said about Dr. Brown.
Where is this in the record?
It's in the motion, the motion for the new trial. We did not discover that information.
Where is the factual support for this in the record?
The factual support is the fact that we actually got the Attorney General's office to provide to the court those records, because what we did was we took the.
We're talking about a lot of different things here.
Okay.
You said that you basically just accused Dr. McHale of spoliating evidence.
Yes, absolutely.
Apart from that accusation, where is it in the record that he did this? Do you have evidence that this happened, and can you point me to an exhibit number in the record?
I have evidence. The evidence is twofold. Number one was the emails from the Attorney General's office and the affidavits which they provided saying the records that they have are different than the records that we were given. And they took those records and they provided those records that they had to Judge Gentry for an in-camera inspection. And the defendants admit that those records were different. They just say it wasn't a spoliation thing. The record that
all you have is evidence that there were differences. You described it as though Dr. McHale came in the middle of the night and pulled materials from a file. I'm not hearing evidence of that. I'm hearing evidence of a discrepancy.
The materials that were removed are admitted by the defendants to have been removed. They just say that was part of the normal routine editing of the documents. And they admit that it was Dr. McHale who did it on that following Tuesday. And if you look at the records that we've gotten, you can see the date that they were amended. So they're on the record. So we know what date they were amended. And we know they were amended the Tuesday after the Monday where the subpoena was issued.
And the subpoena was issued how long before the oral argument?
The subpoena was issued on 2000, it was April. It was, I believe, it was April 19th, 2009, because
all this happened years before the motion for summary judgment.
Right, and we weren't allowed to find out any of that information because when we made our public records request to the board before filing the suit, the board said we will not give you any more information that is other than that is in the public record. We only got this information by an extraordinary act by getting the Attorney General's office involved after the ruling on the motion for summary judgment. What I did was I saw the basis for Judge Ray's motion, which was we were not able to connect who made the anonymous call to the podiatry board, and we were not able to say where this quote in the public records that was attributed to McHale came from, because it wasn't in our copy of the medical records. So we wanted to know whether or not they would at least tell us if they had where they'd gotten this quote about Dr. Brown's drinking habits, which they attribute in the public records to Dr. McHale, because obviously Judge Ray found that we had failed in that area. We had asked for information before and been turned down. What happened was Sarah Pentnant was no longer there. She was out on leave of absence. I contacted the Attorney General's office and said, here's a copy of this ruling. Here's what we're trying to find out. Here's our medical records that we've got. Do they match your medical records? And they came back and said, no, they don't match our medical records. I asked them how they got their medical records, and this is when the story came out. And then I sent a letter to Mr. Kent, and then we filed motions with with Judge Gentry, and we got the Attorney General's office to supply those records. So we could not have learned all this.
You filed a document, you're saying, that specifically has Dr. McHale criticizing Dr. Brown's alcoholism?
The Attorney General's office provided it. We don't have a copy of it. Was
it ever before any Superior Court judge?
Yes, Judge Gentry, on the motion for a new trial.
Okay.
She was given it in an in-camera, but it was not given to us because of the board privilege. We still have not seen the record. The defendants have seen it, and they've admitted it's been changed. Judge Gentry seems to have seen it and acknowledges it's been changed.
But you don't know what it says.
I do know what it says. I know what has been missing. I know what's pulled out, at least the references to Dr. Brown having a habitual drinking problem because he's in the emergency room with a .38. There's a portion that's quoted.
Those are two different assertions.
No.
He's in the emergency room with a point. Oh, so you're saying that Dr. McHale simply evaluated that he must have a habitual drinking problem because he was conversant at a .3.
And he put that into his first draft of the medical records. Those records were obtained by the board.
Hold on. You said he put those in the medical record. When did he put those in the medical record?
The night he dictated on the 16th or the 17th.
But in those medical records, he didn't identify him as Dr. Brown. He identified him as his patient. The point of failure of proof that Judge Ray found was that Dr. McHale knew that this person he was treating was Dr. Brown. Right,
and this is why I'm saying, because the fact that what happened on the following Monday and the following Tuesday was not known to Judge Ray. And if he had had all that additional information about, the subpoena being issued, Sarah Pentnant going down, this going through legal, our expert now saying this obligated the administration to find out if Dr. Brown was one of their doctors, and then the changed records. If he had had all of that information in front of him, there's no way he could have granted this motion for summary judgment and said, there's no issues of material fact. He could not have done that because those circumstances would raise a material issue of fact. Plus
well, they would if they were established, but I'm still not seeing in the record where it's established that Dr. McHale even knew he was treating a doctor.
Well, that's what Judge Ray said without the information about what happened on Monday and Tuesday. Okay, the reason he didn't have
nothing about what happened on Monday and Tuesday, as far as I can tell, still establishes a link between Dr. Hale and a knowledge that Dr. Brown was this alcoholic patient.
But it does establish a link between the administration, of which he is a part of. Again, this is where the administration failed, not just Dr. McHale. After what happens on Monday, once we learn that our expert submits testimony in the form of affidavit that says this changes the standard, and at this point the hospital has an obligation to make sure it's not one of their guys, and they didn't do that obligation. They never looked into his background, despite all the stuff that had now happened that people in the administration knew about. So I have a minute and 26 seconds. I'm going to reserve some time if that's okay.
All right, thank you, counsel. We'll now hear from the hospital. Well, Dignity Health.
Thank you, Your Honor. May it please the Court, I'm Richard Kent, and I represent the Applee Dignity Healthcare, formerly Catholic Healthcare West. I'm here to ask this Court to find that the Court below did not abuse its discretion by granting Dignity's motion for summary judgment. The Court's decision below should be affirmed. Appellate's brief is full of irrelevant allegations and unsupported allegations, which I call fiction, not in the record, much like some of the argument that you just heard. I'm going to give you one example of that fiction, and then I'm going to turn to the two issues raised.
Why don't we jump there now? Gone through at least all of the motion for new trial. Is there evidence there suggesting violation of medical records?
No, sir, none.
Okay.
And indeed, if you want me to address that first, I will, and that's fine. The issue that the plaintiff appellant raises concerning the medical records, I will address that. Dignity Health did not produce the entire medical record is the claim. It's simply not true. In that regard, I want to refer to the vagaries of the electronic medical record. I know that Judge Swan knows much about that because he educated me when he was on the trial court in a case that we had about what metadata was, which I had never heard of prior to Judge Swan raising it. In the years since, I've heard a lot about metadata, and I've learned a lot about the electronic medical record. So let me tell you what happened here, and this is all in our brief. On April 16th of 2009, Dr. Brown presented to Chandler Regional Medical Center, and Dr. McHale treated him and dictated his preliminary report. At this point, it is a preliminary report, which I sometimes call a draft, because Dr. McHale had not yet electronically signed his report. And right on that document, it says, on its face, it is preliminary unless signed. The preliminary report, dictated on April 16th, was transcribed on April 17th. On April 20th, a clerk, and the idea that this went up to some legal department, by the way, it didn't. I would have been called. I wasn't. And in fact, what happened was a clerk presented the preliminary report of Dr. McHale to the podiatry board. The preliminary report was then edited by Dr. McHale on April 22nd and electronically signed on April 26th. As of April 26th, the preliminary report no longer existed in the electronic medical record of Chandler Regional Medical Center. After April 26th, anytime anybody asked for a medical record, the department printed out the entire medical record, and it would include the final report. There was no way to get to the...
Did the preliminary report exist anywhere within the possession of CHW at that time?
No, sir.
It was deleted, scrubbed.
Exactly. That's what happens. And that's what we put. We have an affidavit from the expert in Dignity on the electronic medical record explaining, and if you think about it, Judge, it makes a lot of sense. You don't keep unedited reports. There's a lot of things in there, and you can't keep that. It's not part of the electronic medical record. You may be thinking, well, couldn't some forensic expert get that? I don't know. I've never looked into that, but that is a forensic expert issue. What we do know is that when the electronic medical record is produced, the final report is all we have access to and all that is produced. And at the time of the medical record request, of course, I wasn't involved in the case at the time.
Hold on, because
Yes.
I'm trying to keep this. So Dr. McHale does a preliminary draft report immediately after treating Dr. Brown at the emergency room.
That's correct.
All right. And that was on what day of the week?
April 16th, I believe it was Well, actually, the dictation was on, let me explain. He came in late at night on the 16th, on the 17th. On the 17th.
All right.
16th or 17th.
And then you said just a minute ago that that preliminary report was sent to the board. When was that communicated to the board?
April 20th.
Why would they communicate it to the board if they didn't know at that point in time that it was Dr. Brown?
The board obviously knew that Dr. Brown, the podiatry, you have to understand what happened here.
Communicated it to the board.
The clerk. Let's talk about the clerk. I think that's who Judge McMurdy's asking about.
Right. What we're saying is that apparently Sarah, and you just heard it, Sarah Penttinen brought a subpoena to the clerk, gave it to the clerk, and the clerk gave the preliminary report, and in fact, not just the preliminary report, the entire...
It was produced as pursuant to a subpoena. It had nothing to do with Dr. McHale or anyone in his staff sending the report to the board.
Well, that's correct. And may I point something out about Dr. McHale? If you hear this argument, you'd almost think that I represent Dr. McHale. You would almost think that Dr. McHale was a defendant in this case. And yet nothing could be further from the truth. When this complaint was filed in this case, Dr. McHale was not named. And indeed, when I filed an answer on behalf of Chandler Regional Medical Center, it was in March of 2012, over 2 years past the treatment that was given in April of 2009, the statute of limitations had run as to Dr. McHale. We had no reason in this lawsuit, as we were defending it, Mary Isban on behalf of Mercy Gilbert Medical Center and myself on behalf of Chandler Regional Medical Center, to think that this lawsuit involved Dr. McHale. I was defending Chandler Regional Medical Center, not Dr. McHale. My clients were the nurses and employees of Chandler Regional Medical Center, not Dr. McHale. So what we have here is a situation in regard to the electronic medical record that when it was requested, the entire medical record was provided. And then what happened in regard to the electronic medical record? This is an important point. In August of 2012, the plaintiffs requested and received the minutes from the April 27, 2009 Podiatry Board meeting. Now, it was on that day, April 27 of 2009, that the Podiatry Board summarily suspended the license of Dr. Brown. That was 3 days after the surgery, which it is at issue here. We know that because the plaintiffs produced the Podiatry Board information in their fourth supplemental disclosure statement in August of 2012, 3.5 years before judgment was entered. The minutes of the Podiatry Board in the hands of the plaintiff contained the statement of Dr. McHale that the plaintiffs now say they don't have. They've had it since August of 2012. The minutes noted that Dr. McHale had opined that Dr. Brown obviously consumed alcohol on a regular basis due to the fact that he could speak and converse with a blood alcohol level of 0.38%.
Did the minutes indicate that Dr. McHale identified Dr. Brown as Dr. Brown?
No. No, what the minutes indicate is that the Podiatry Board minutes indicate that he had obviously consumed alcohol on a regular basis due to the fact that he could speak and converse with a blood alcohol level of 0.838%. That was changed by Dr. McHale. That was his preliminary. But here's the change. Let me read that, because that's important. Alcohol intoxication, ETOH, or alcohol level 380 with a patient moderately awake and speaking, stable vitals. That's the final report. So it's easy to conclude from that Dr. Brown, or this patient as he calls him, was someone who regularly consumed alcohol. If you know anything about, and I don't claim to know much about it, but I know enough about the alcohol level that 380 is very high, and if he's able to converse and speak, he obviously drinks alcohol on a regular basis. But that's not me. That's their expert. Their expert, who, yes, we did depose, said he drinks alcohol on a regular basis because he was speaking and he was awake and he was at 0.38. This is not news to anybody. And so
Mr. Kent.
Yes.
In the preliminary report by Dr. McHale or the final report or any iteration between, did Dr. McHale ever refer to Mr. Brown as Dr. Brown?
I don't believe so, but not that I recall, and I think that's why it was presented to Judge Rea below, and he found two things. He found that he didn't know he was a doctor, and he certainly did not know he was a doctor on staff. And those are the two things.
Are these documents we've been talking about anywhere in the record?
Yes, sir.
Both sets?
No. What's in the record is the final report.
Okay.
All right.
But the original report is not in the record.
Well, it is to the extent that the podiatry board records are in the record.
To the extent that it's reflected in the minutes, but
Yes.
but the actual original document is not available for us to review.
No, it is not.
So then, just to nail this down, there was a subpoena to which a clerk responded before the final report had superseded the preliminary report, correct?
Correct.
What prompted the subpoena to go to a clerk who would have access to Dr. McHale's preliminary report if nobody knew that Dr. Brown was a doctor?
Well, remember, there was an anonymous call from someone to the podiatry board, we've never known who, and said that Dr. Brown had presented to the emergency department at Chandler Regional Medical Center and he was intoxicated. So the podiatry board knew. And that's why the podiatry board at that time instigated their investigation. And that's why on April 27th of 2009, the podiatry board suspended Dr. Brown's license.
At what point was the identity of the anonymous caller known?
It's not known. It's still not known.
Still not
We
known.
have no clue who this anonymous caller was. We still do not know. What we know is that Chandler Regional Medical Center did not find out, the administration did not find out about Dr. Brown's visit to the emergency department in a drunken fashion until after his license was suspended on April 27th of 2009. So what we have is a situation where Judge Rea said, wait a minute, isn't this really the situation? Don't we still have to look at the issue of whether or not there was knowledge of the folks on the night of April 16 of 2009 in the emergency room about whether or not he was on staff? And frankly, on page 49 of the May 7, 2015 oral argument, here was the exchange between Mr. Baumann and the court. So there's Schmidt, the hospital administrator. Schmidt does not opine that there was any or no liability simply by virtue of knowledge that Dr. Brown was a licensed physician. Mr. Baumann, right. If there's no indication, this is still Mr. Baumann, if there's no indication that anyone at Dignity had an idea that Dr. Brown was a Dignity physician, then they are not obligated to report to anybody to the board, but to the board. So then the judge says, so then we have to focus on the evidence that the nurses or the staff in the ED knew that Dr. Brown was on staff. Mr. Baumann, that's correct. Court, so of all of these things we've talked about, what indicates knowledge of the staff that Dr. Brown was on staff at Dignity? In other words, did the nurses and the folks that I represent know that Dr. Brown was on staff? And what he found was there was no evidence to show that any of those folks knew that Dr. Brown was on staff.
Why isn't the anonymous call itself circumstantial evidence from which one could find that somebody in the hospital knew who Dr. Brown was?
Well, why couldn't it be his ex-wife? By golly, it seems to me that the wrath of an ex-wife is more probable than anybody at the hospital, because the ex-wife was actually called, the family was called, and we don't know if it was somebody from his family, we don't know if it was his ex-wife, and it is not reasonable to assume that it was anybody that I represent from the hospital. That's why. And I want to point out another thing, and I think this is important, because I was talking about the fact that Dr. McHale was not named in this case originally. And the fact is that the negligence of Dr. McHale was never appropriately before this court. And here's why. Oh, and by the way, I want to do this when I respond to the question, because the claim is that we should have produced this contract earlier, and it seems to me that that's begging the question of, was Dr. McHale's negligence ever properly before this court? The simple and straightforward answer is no, because this court knows full well that in a medical malpractice action, in order to put the claim that an emergency room physician was negligent in front of the court, you need an affidavit of merit. You do not need an affidavit from
I don't think
Mr.
there's
Schmidt.
any argument that Dr. McHale committed medical malpractice.
Oh, yes, there is. That's the only argument that they have in regard to Dr. McHale. Follow me. They are arguing, it seems to me, that Dr. McHale, as a physician in the emergency department, should have reported, if he knew that he was a physician and on staff, that he should have reported that to administration as a physician. The only one who could really address whether or not that is the standard of care of an emergency room physician is an emergency room physician.
Why is it as a physician? What
Because
if the CFO of the hospital happened to be in the OR waiting room that night and noticed Dr. Brown, recognized Dr. Brown, and did nothing about it? Wouldn't the CFO, who presumably is not a physician, give the same constructive notice to the hospital?
Then you would have to have a hospital administrator who would testify to the standard of care of a CFO. I don't know what the standard of care of a CFO is in that regard, but the chief financial officer may not have anything to do with credentialing and may not know anything about credentialing. And speaking of credentialing, by the way, there is not one shred of evidence.
What if it was the IT guy? Some hospital employee knew this and didn't report it.
Well,
does it matter?
It matters a lot.
Or...
And here's why it matters. Because now we get to duty. So what we have to talk about is, does the IT guy know or have any reason to know that he should report this to administration? We don't know the knowledge of an IT guy. That takes expert testimony. And the fact is, just to presume that if you're an IT guy, you know that this is something you should report, I don't think you can make that presumption. I don't know the standard of care of an IT guy. I don't know the standard of care of a CFO. I don't know the standard of care of an emergency room physician, but the point is that in order to talk about the standard of care of an emergency room physician in this case, you do need an expert. And there are three things that I'd like to point out.
Well, I mean, I'm not sure how far this expert thing goes when you're not talking about a physician performing medicine. When you're talking about a physician acting in a observational or representative or managerial capacity, are you telling me then that if Dr. McHale is a board-certified podiatrist, that the expert affidavit would have to come from a board-certified podiatrist talking about what the duty to report drunkenness is?
ARS, that's not my law. That's ARS 122604 makes that very clear, I believe. ARS 122604.
Anything a doctor does just because he's a doctor?
That's what the statute says, Your Honor. The statute says ARS 122604. If you're going to talk about the negligence of a physician, you have to have a physician prepare and provide an affidavit of merit. That's 122604. That's the law. I want you to think about this. Let's think about this for a minute. If Dr. McHale had been sued, and they say Dr. McHale fell below the standard of care by not reporting it, wouldn't you need an affidavit of an expert to say he fell below the standard of care under 122604? The answer, it seems to me,
that's not the case we have here. We have the case here. The Dignity Health was sued, and the question is whether somebody who was within Dignity Health had a duty to report that. That's a separate issue. And let's get back to what evidence was there that Dr. McHale knew or should have known that Mr. Brown was Dr. Brown, a credentialed person for Mercy Gilbert?
Well, if all due respect, Your Honor, by asking the question, you're putting the cart before the horse.
Well, that's okay, because I get to ask the question, so
well,
you
I
get to
understand
answer
that.
it,
Well,
please.
the first answer is we are not responsible for Dr. McHale. Dr. McHale is not.
That's not my question. My question is there any evidence that he knew that Mr. Brown was Dr. Brown?
No, there's no evidence, and that's what the judge below found, and there was no abuse of discretion in finding that. Furthermore, I do want to point out that the contract makes clear that he is an independent contractor, that he is not, by the way, a part of the medical executive committee, that he is not a part of the credentialing committee, and if you look at the contract, which you have and the court below had, that is clear. He was made the medical director, but despite that, The contract says he is still an independent contractor. That's number one, for which Dignity is not responsible. And number two, it sets forth his duties in Exhibit 2.2, and it says what his duties are, and none of that makes him a member of the Medical Executive Committee, and none of that makes him a member of the Credentialing Committee. That is another fiction, and I defy the plaintiff appellant to show you in the record where it says he was made a member of the Medical Executive Committee or the committee that they claim he was a member of, because he wasn't, not credentialing. Thank you.
Thank you, Mr. Kent. Counsel?
Thank you, Your Honor. Let me address briefly where in the record is the issue of the altered records. If they, starting in exhibit number or index of record 392, 405, 412, 414, 415, and 416, you'll see all of the motions regarding the in-camera inspection of these records, which I have never seen. I don't know what happened to the records that were submitted to Judge Gentry, but Judge Gentry has those records, or had those records. Now, with regard to the argument that you just had, Dr. McHale is the chairman of the emergency department. He is the administrator. There's nobody in the emergency department who's higher than he is. And where it says that he's part of the executive committee and on the credentialing committee is in the bylaws of the hospital. And we went through this whole argument in the previous argument before where Dignity filed for motion for summary judgment on behalf of Mercy Gilbert, claiming we had sued Mercy Gilbert. We went through that whole thing about why the records make him the medical part of the joint credentialing committee. But here's the point. This motion was granted on an incomplete record before it should have been granted. Now we know that information that was crucial was withheld, including what happened after the day in question. What we have here is a case that was cut off prematurely. We have submitted expert affidavits saying, number one, that those medical records
Counsel,
would have been
thank
held.
you very much for your time. Your time has concluded. The matter is deemed submitted. A decision will issue in due course.